is Carl Pearson, and I'm going to talk about a little-known constitutional right that will make you more powerful than the President of the United States, at least when you are in a position to exercise that power. It is one of the checks and balances built into the U.S. Constitution, and let me explain. The title of this is Jury Nullification is a Right. The Seventh Amendment to the United States Constitution provides, and I'm quoting now, in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Language may be a little bit convoluted, but it says that when a jury determines the fact, the jury's decision should normally be upheld by the judges. The problem that I see is that billion-dollar companies are able to buy jury verdicts, especially in very important business and economic cases, because they have money to spend to purchase all sorts of video or graphic displays to the jury. And the plaintiff is broke, usually, and can't do the same. Then the judge tells the jury that they are required to follow the judge's instructions, jury instructions, which ordinarily, in many cases, favor the billion-dollar companies. And the reason for this is that over the years, the courts have rendered many, many decisions that surprisingly, or maybe not surprisingly, favor large companies and make it difficult for small companies to try to win in a court lawsuit, in a court battle. The result is that the small business or individual victims lose too much of the time. There's various reasons that I see for juries rendering unjust decisions in important economic cases. One is that the monopolized press constantly tells the public that lawsuits are bad. So the public begins to believe that. They don't know. They only understand what they're told, and they're not told the truth. Economic cases are often long and tedious, with no press interest to alert the jury to the importance of the case. 3, the important economic issues are kept from the jury by the nation's press, which wholly disregards most economic lawsuits which could have an impact on the wealth of the major corporations, so that the public does not find out from the press what the issues are. 4, expert opinions and reports from the economists that are retained to testify by the defendant major corporations are permitted to testify as to their opinions with too few restrictions. And finally, jury nullification, that juries are not told that they have the right to render a just verdict even though it may not adhere to the jury instructions given to them by the judge. So these are some of the reasons that I feel that the juries are not rendering decisions as they should in favor of the oppressed, the victims of corporations and major corporations and government. They wouldn't lose all these cases if just one member of the jury was aware of the constitutional right of jurors in this nation to disregard the judge's instructions and render a just verdict instead. Judges do not instruct the jury that they have the right to disregard the judge's instructions and are told instead that they must follow the judge's instructions. When the judge tells jurors that they must follow the judge's instructions, there is an implied threat that if they do not, the judge could take some action adverse to the jury or certain of its members, such as holding them in contempt, or putting them in jail, or doing something that fining them, taking away their house. The jury doesn't know. But the judge has no power to hold anyone in contempt or to penalize them for jury nullification. The reasons that the public doesn't know about this constitutional right to nullify the judge's instructions are that the judges don't tell the jury and the newspapers don't tell the jury, because they generally slant the news to favor the major corporations and government officials and agencies. And jury nullification is a right when exercised, which would take away money and power from the rich and powerful, who are the friends and owners of the nation's main media. Letting judges decide factual issues instead of juries is not the answer. Don't be fooled by that argument, that we ought to just turn over the factual determinations to the judge. The reason for juries in the first place is to reduce the power of the judge. When a major corporation has to face a jury, it does so with more fear than it has when facing a judge. Usually when someone who has been an attorney for established interest before becoming a judge, and who often is sympathetic with major corporations and government interests as a result. The fear of a jury is the fear of having 12 individuals, perhaps 6 individuals, from various walks of life, some of whom may not be happy with losing their jobs, or losing their homes through foreclosure, or suffering from a declining standard of living, and to determine who is to win a lawsuit, especially if the jury finds out that it has the constitutional right of nullification. Because of juries and the right to nullify the judge's instructions, more cases are settled by major corporations and by government agencies than would be the case otherwise. Without juries and the right of nullification, the oppressed wouldn't be able to win or settle as many cases as they do, and they would decide to sue even less. So we don't want to eliminate jury nullification. We don't want to have judges deciding cases. What we want to have is more jurors know that they have a right to render a just verdict in a case without any reprisals, and to do so as a matter of law, but they won't be told that by the judge. My name is Carl Pearson. I have a pretty good website on the issue of jury nullification at this address, lawmole.com/jurynullification.php. I look forward to having